Good afternoon. My name is Josh Blackman. I am the president and founder of the Harlan Institute. I'm coming from you live from the CUNY Law School in Queens, New York. And it's my honor to welcome you to the sixth match of the Harlan Institute Consorts Virtual Supreme Court competition. Today, we are mooting the case of Carpenter versus United States. And from Creekview High School, we have Mahak and Simon. And from Stuart High School, we have for respondents, Matthew and Tiana. Julie, is there anything you'd like to add before we get started?
I want to congratulate both teams for making it this far and wish you the very best of luck as we begin the round. The more questions you get from us, the better, so don't be shy when we start asking them, but we will give you about a minute or so to begin before we hop right in.
Very good. So if there are no further questions, petitioner, counsel, you may begin whenever you're ready.
May it please the court. My name is Simon Pena.
My name is Mahak Merchant.
And we represent the petitioner, Mr. Timothy Carpenter, in today's case.
In our time before the court, we intend to show that Mr. Carpenter's rights against government intrusion under the Fourth Amendment were violated by actions taken by the police in the case before the court today.
Would this court benefit from a brief recitation of the facts?
4 men, including the respondent, were arrested in connection with a series of armed robberies. One of the alleged conspirators gave the phone numbers of all of the other participants, as well as his own, to the police, without the knowledge or consent of people who those phone numbers belonged to.
Using these phone numbers and without obtaining a proper warrant, the police acquired transactional records from those cell phones. These transactional records included, but were not limited to, the phone numbers dialed and the calls received, as well as cell site location information data, or CSLI data.
The combination of these transactional records and the cell site location information data spanned over 127 days, which the government relied on when charging the petitioner, Timothy Carpenter, with aiding and abetting robbery that violated interstate commerce.
The lower court ruled in favor of the state, and this court has granted certiorari to hear oral arguments based on the issues stated before.
In order to show that Mr. Carpenter's rights under the Fourth Amendment were violated, we will be addressing 3 points in our time before the court. 1. There was a search and seizure of Timothy Carpenter's persons, houses, papers, or effects. 2. That the government did not obtain a proper warrant. And 3. That the third-party doctrine should not be applied in the case before the court.
First, there was a search and seizure of Timothy Carpenter's persons, houses, papers, or effects. The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The opposing counsel would base their argument on an overly restricted view of the Fourth Amendment in stating that a person's cell site location data is not a person, house, paper, or effect.
However, in response to this, we would state that this court, it has been explicitly stated in the Telecommunications Act of 1996, Chapter 22, Section 47, in general, every telecommunications carrier has the duty to protect the confidentiality of the proprietary information of customers.
And according to that same code in Section C3, the customer has the right to request access to their own proprietary information and the right to give that information to anyone they might see fit. Not only is it described in this section that the information is crucial to the privacy of the customers, but it describes a property interest that allows the customer to control who sees this information, when they see it, and under what circumstances.
We can find no major difference between the rights that would be prescribed to a person should they possess these physical papers and a person's right to their cell site location information data. However, in today's case, not only did the government conduct a warrantless search, they also seized private documents and interfered with Timothy Carpenter's property. A seizure occurs when there is some meaningful interference with an individual's possessory interests, as held in United States v. Jacobson.
However, Dickman v. CIR held that a person need not possess all of the bundle of sticks of property rights in order to have a protected interest in a location or thing. Timothy Carpenter did possess a right to his papers, and that right was violated.
The seizing of documents that tracked Timothy Carpenter for 127 days is unconstitutional under the Fourth Amendment, whether the papers were physically taken from his possession or just obtained with depriving him of any physical object.
Justice Brandeis, in his analysis of the Fourth Amendment, addressed the similarities between these two situations by saying, "It is not the breaking of his doors and the rummaging of his drawers that constitutes the essence of the offense, but it is the invasion of his indefeasible right of personal security, personal liberty, and private property, where that right has never been forfeited."
So, Counselor, if I could interrupt you very briefly, how many days was the search in this case? How many days of data were they looking for?
It was 127 days.
Okay, so I think you would probably argue 127 days is too much, right? Where's the line that we should draw?
Yes,
how much of a search can be performed under the Stored Communications Act without having to go to a federal judge and seeking a warrant?
Necessarily the amount of days that Timothy Carpenter was tracked, it's the information that the government obtained. Over this 127-day period, the government obtained 12,898 data points from Timothy Carpenter alone. The invasiveness of this search violated Timothy Carpenter's right to privacy.
Counsel, if I may, we have to write an opinion. So is it your position that any search under the Stored Communications Act for the cell phone data is invalid? Is there any permissible search that's even allowed?
Your Honor, our second contention to this court is that these court orders for disclosure that are addressed under the Stored Communications Act do not fulfill the warrant requirement of the Fourth Amendment. The Stored Communications Act and court orders for disclosure do not present the same requirements as a warrant. Therefore, because the warrant requirement would not be fulfilled with the issuance of a court order for disclosure, it would constitute a violation of the Fourth Amendment.
Further, even if the...
Sorry, I just want to ask a clarifying question, right? So you're arguing that, one, the procedures of the Stored Communications Act, as they apply to cellular technology today, are not sufficient, and therefore you would require a warrant, right?
Yes, Your Honor.
Yes.
So it's the Stored Communications Act's application to cellular data that is problematic.
Yes, Your Honor.
Okay. So do you just want us to look at its application in that circumstance, or are you asking us to strike down the entire Stored Communications Act?
Well, Your Honor, for this court to rule in favor of the petitioner in the case before the court today, it must only find that the application of the Stored Communications Act to the issues before the court would violate the Fourth Amendment. However, this court is perfectly welcome to expand its ruling into whether or not the Stored Communications Act itself is in violation of the Fourth Amendment. However, that is not the basis of our arguments today.
Okay, thank you.
But are you arguing that the Stored Communications Act is are you arguing that in this case the SCA violates the Fourth Amendment?
Yes, Your Honor, because unlike the Fourth Amendment, the Stored Communications Act does not have a portion that requires an oath, affirmation, or something that comes from a trustworthy source. And unlike the Fourth Amendment, the standard is not probable cause, it's reasonable grounds. Therefore, by the government trying to obtain this quasi-warrant to surpass the requirements of the Fourth Amendment, it's a violation of Timothy Carpenter's Fourth Amendment rights.
And Your Honor, to expand on that, according to Bryan Garr versus United States, in order to prove probable cause, a person must show acts and circumstances within the officer's knowledge and of which they are reasonably trustworthy information that are sufficient in themselves to warrant a belief by a man of reasonable caution that a crime is being committed. However, again, to get a court order for disclosure, the opposing counsel must only show specific and articulable facts to show not that a crime has been committed or will be committed, but that the information sought is relevant and ongoing to a criminal investigation. This relevance test, in our view, does not meet the requirements of the Fourth Amendment, and therefore, in application to today's case, would be unconstitutional.
And even if the warrant requirement of the Fourth Amendment is fulfilled by the Stored Communications Act, the requirements to obtain a court order for disclosure under that act were not met, as the impartial magistrate abused the discretion in allowing the FBI to obtain overly voluminous information.
The Stored Communications Act states that a court issuing an order pursuant to this section may quash or modify such order if the information or records requested are unusually voluminous in nature. This shows, Your Honor, that the legislature is enacting this law and that was enacting this law had an interest in limiting the amount of information that might be obtained through this quasi-warrant.
Further, the Fourth Amendment protects people of the United States from unreasonable searches and seizures. This shows that the framers of the Constitution had an interest in reasonability of the proposed searches that they were allowing warrants in.
And Your Honor, while the Stored Communications Act does allow 180 days, we can see through cases like Jones that in some situations it might even be considered that a month is an overly prolonged period of time.
So counsel, let's talk about Jones for a minute, right? How does the Jones case impact this case?
Well, Your Honor, the Jones case, in being a physical violation of Mr. Jones's property in that the police had to attach a GPS onto the car, is separated from this case somewhat. However, we can see from that case that Mr. Carpenter and Mr. Jones both have a reasonable expectation of privacy in their location, even through public thoroughfares, as well as we can see that in some instances there might be that in some instances, even a short of a period as a month might be considered an overly prolonged period of time.
And Your Honor, to add on to that, Kylo versus United States held that a police officer is not able to tell the intimacy or the invasiveness of cell phone site location information just by looking at it at face value. And that is why it is required that they get a warrant to make sure that all Fourth Amendment rights aren't violated.
Your Honors.
Well, but Counselor, if I can interject, in the Jones case, wasn't there an important factor that the GPS was physically attached to his car? Here, there's no physical intrusion. Rather, this is data that Mr. Carpenter voluntarily shared with the cell phone companies. Isn't that different?
Your Honor, the physical intrusion, the doctrine that you were referring to in that you must have some sort of physical intrusion in order to violate the Fourth Amendment has been struck down many times by this court. And further,
hold on. But that was Justice Scalia's majority opinion. I'm not sure what was struck down. That was the majority opinion.
The idea that in Jones, one of the crucial portions, yes, Your Honor, was that the police did violate the physical property that Mr. Jones possessed. However, the idea that the only way to violate the Fourth Amendment.
No, I didn't say only. I didn't say only. But here, this is not like Jones, where the police put a device on his car. Mr. Carpenter was voluntarily sharing his information with the world by using the cell phone. Isn't that a difference?
Not necessarily, Your Honor. Cell site location information is produced even in passing. For example, if Timothy Carpenter was to get a phone call or a text message that he wasn't expecting, the cell tower surrounding him would still collect that cell site location information data. So although he may have signed up for the contract, he didn't necessarily consent to every single piece of cell site location information being collected.
And Your Honor, correct me if I'm wrong, but the question you're asking is moving into the idea of if Mr. Carpenter did have a reasonable expectation of privacy. And in our reading, to determine if someone has a reasonable expectation of privacy, according to Katz versus United States, you must show two things. First, that a person has established and exhibited an actual subjective expectation of privacy, and second, that expectation be one that society is prepared to recognize as reasonable.
Mr. Carpenter did exhibit an actual expectation of privacy. This section requires nothing more than an analysis of Mr. Carpenter's actions to determine if he felt that the information that was obtained would have been protected.
In this instance, it would be fairly simple to determine that Mr. Carpenter's actions from bringing this lawsuit to keeping his phone on are indicative of a feeling that he was safe in carrying his phone with him. Therefore, Mr. Carpenter did have a subjective expectation of privacy.
Mr. Carpenter must show that society is prepared to recognize that expectation as reasonable. In order to determine the reasonableness of Mr. Carpenter's expectation, we must only look at the rulings of the Federal Communications Commission, or the FCC, as a subset of the legislative branch of the federal government. The FCC has determined in Section 222 of the U.S. Code that society is willing to recognize your expectation of privacy in your cell phone records.
And to bolster this, Your Honor,
hold up. But I mean, when you look at a cell phone contract, right? When you look at a cell phone contract, it says we can share this with the government. T-Mobile, for example, says that. You know, that's very nice what the FCC said, but that doesn't bind us. Why shouldn't we just say if people voluntarily share information with the cell phone company, then that's good? Is this not Smith against Maryland?
Your Honor, it is true that some cell phone companies do include in their contracts that the cell phone company is able to share this information with the data, but we contend that that is simply to protect the companies themselves from being sued by their customers, not to give the government complete access to any records that might be kept for the business purposes of the cell phone company.
And Your Honor, to add on to that, in Smith versus Maryland, the federal government had installed a pen register on a phone. However, this is much different. It's one thing to obtain the cell phone numbers that a person is called. It is another thing to track the data points and the location points that a person has been to, because that can reveal information that's far more intimate and far more invasive.
Well, why should that make a difference? What's the difference between the person you're calling versus the place you're going? Why should that be a difference? Why is the pen register any different than the cell phone data being stored in this case?
So with Smith versus Maryland and the pen register, it was shown that that there was no reasonable expectation of privacy, as it falls under the third party doctrine. There was that this was the business practices of the company. They had to keep these records. However, in today's case and in Jones versus United States, it has been shown that people do have a reasonable expectation of privacy when moving through public thoroughfares in their location. And further, Your Honor, the location of somebody is much more sensitive in general than just the numbers that they are calling, just as the content of a phone call might be more sensitive. Your Honor, further moving into the third-party doctrine, the third-party doctrine relies on a separate legal concept for the determination of the reasonable expectation of privacy, this concept being consent. The truth of the matter is that much like a large population of the American population, Mr. Carpenter was unaware that he was being tracked every time that he called someone.
Many of the people who own cell phones today are unaware of the fact that your location information is stored.
And Counselor, you have about 30 seconds left. I keep muting myself and your warnings don't get through. I'm sorry. It's about 30 seconds left.
Your Honor, it is for the reasons previously stated that we pray that this court refuse to allow the government to use the Stored Communications Act to bypass the Fourth Amendment and to rule in favor of Mr. Carpenter, the petitioner in today's case. Thank you, Your Honor.
Okay, there we go. All right, Counselor, thank you so much. All right, I'll put you on mute and we'll move ahead to the respondents. You have 15 minutes. Whenever you're ready to begin. Oh, you're still on mute.
You need to unmute.
Yeah, sorry, I didn't start your time yet. You have to unmute it, please. Okay, try it now. You're still on mute. Okay, now we can hear you. Okay, when are you begin? I'll see if you begin.
Good evening, Your Honor. My name is Tiana, and together with my co-counsel, we represent the respondent, the United States government, in today's case. The facts of the case are as follows. In 2011, 4 men were arrested for armed robberies of stores such as T-Mobile and Radio Shack in Michigan. After one man came forward about his participation, the government intervened by asking magistrate judges to obtain his cell records to find others who were potentially involved. Following the completion of the retrieved information, the government was able to pinpoint 2 men, one named Timothy Carpenter. Carpenter claimed that the actions of the government violated his Fourth Amendment rights. However, the government was not in the wrong for their obtainment of Carpenter's transactional records as they spotted through the Stored Communications Act. The Fourth Amendment grants individuals to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures by the government. In Carpenter's case, a warrant was not needed as the information collected and utilized by the government was supplied by a third party, that being the cell phone provider. United States v. Miller specifically states, the Fourth Amendment does not prohibit the obtaining of information revealed to a third party. Otherwise stated, willingly shared information, such as cell records, are not shielded by the Fourth Amendment, given the fact that the phone company voluntarily granted the government access and Carpenter willingly allowed said information to be collected. Therefore, the United States did not overstep their boundaries and wrongfully violate the Fourth Amendment rights of Carpenter, as the amendment does not apply to the conditions of the case.
Counselor, can I ask you a question? Do you think most cell phone users are aware of how their cellular data is shared with the cell towers such that it could be used to track their movements and locations?
Given the fact that the individual signed the terms and conditions instituted by the cell phone provider, an individual signs their rights to be shared with other individuals.
Let me ask you a question. Do you own a cell phone?
Yes.
Did you read the terms and conditions before you signed it to get your cell phone?
Yes.
You read it and you fully understood. So you know every time you send, make a phone call or send a text message, you are transmitting information to a cell tower that could be obtained by the government.
Correct. I recognize that.
Okay. And do you think most Americans recognize that though?
Your Honor, if I could add on to my co-counsel here, I would believe it is the responsibility of the user of the phone to understand how their phone works. To also answer the question you asked my co-counsel, I personally do not own and use a cell phone. And
that's an interesting perspective. So I just want to understand how we should be interpreting the reasonable expectation of privacy. So it isn't that you do know or that the majority of Americans do know, it's that they should know and they reasonably should know. Is that what you're suggesting?
Correct.
Okay, thank you.
With taking into account the aforementioned information, it is important to recognize the distinction between the content of a communication and the information necessary to convey said information. The content of a communication is protected under the Fourth Amendment, as it is intended to safeguard conversation amongst two or more individuals. The information necessary to convey said information is provided through obtaining personal records, which would be an infringement by the government or reasons or persons to possess such information. Smith v. Maryland established this legal principle. The government retrieved the number he dialed, however, keeping the contents of his conversation private, simply for the purpose of linking the location to the occurrence of the crime. This established that the routing information of a communication is not protected by the Fourth Amendment, and the information necessary to convey said information is through locational data. In the case of Carpenter, the government only investigated the call log as it relates to the instituted cell towers in order to link him to the crime. The United States government took the necessary protocol to gather needed information to link Carpenter to the crime. Carpenter's obtained locational log does not shield him from the laws that are upheld by the United States government, thus making the government's actions justifiable.
To expand on some points made by my co-counsel, the information that the government used in Mr. Carpenter's case was owned by the phone company. He had willingly allowed this information to be shared, and the information that the government used was outwardly visible information. It was that phone calls had taken place and to whom they'd taken place, but it was not the contents of the conversation, which is protected under the Fourth Amendment. We're looking at the Supreme Court precedent of Ex parte Jackson. This type of information in that case, which was the address of a letter, it still applies. It's a similar type of communication where a communication is being sent and the government's able to look to who it's being sent to and that there is a communication. Going on with this, Carpenter consensually allowed and signed the contract. The government did not force the phone upon Mr. Carpenter, and to respond to Jones, that was a case where the difference why Jones does not apply to this case is because that was forced. In that case, a GPS tracker was forced on the defendant. In this case, in Carpenter, the government did not force a phone on him, and it did not force the phone to act the way it does. The phone and the information was through the normal use of the phone and being shared with a third party, which had ownership of it. Therefore, it was not Carpenter's information. To move into the locational aspect of this case, and the location, which is obviously on.
A minute ago, you said it's not Carpenter's data. Why is this? Isn't Carpenter voluntarily sharing this with the network, though? Why is this not his data?
Correct. He's voluntarily sharing it. The reason why it becomes not his data is because it's not stored on his phone, and it's stored by the third party, by the cellular provider. So he's given up ownership of it through the use of his phone.
So if he gave up ownership of it, then why is there even a Fourth Amendment issue? Why is this not like Smith versus Maryland?
The difference with this case is that that's what we're relying on, is that he had given up, it was willingly given up. So that does make it not a Fourth Amendment issue, because as we hold, there was not a search that took place for him to contest.
Well, so Counselor, tell me about Smith v. Maryland. What were the facts there?
Smith v. Maryland, and this was a case that established precedent of third-party doctrine. This has to do specifically with records given to a phone company and the voluntarily giving up and sharing information with a third party, Your Honor.
Okay, so I mean, I asked you a minute ago, wasn't Carpenter voluntarily sharing this information? You said yes. So if he's voluntarily sharing this information, why is this just not the third-party doctrine? Why is this not okay under Smith? Why do we need a warrant here?
The suppliance of information by a third party eliminates an individual's entitled expectation of privacy, as the information was voluntarily shared. This legal principle is also known as the third-party doctrine. The obtainment of the transactional records by the United States government, which was granted by the magistrate judges by the third party, that being the cell phone provider. The information gained allowed for the government to trace the location as it relates to the placement of the robberies and convict the participants. They weren't intruding on his conversations, thus making the actions of the government justifiable.
Let me ask you another question. So how many days of data did the government collect in this case?
Over the course of 227 days, Your Honor.
I think there's 127, right?
Right.
127. Do you think there's any limit, or would you give us any limit of when the search is too long, at which point it becomes unreasonable? If 127 days is okay, what about 500 days or 1,000 days? Is there some point where it becomes an unreasonable search?
This type of search, or what you're calling a search in this case, would not be unreasonable, though how much data the government could access would also rely on the cell phone company and how far back they're storing data and how the cell phone company wants to collect it. The government will hold, because we don't see this as a search as defined under the Fourth Amendment, that there would not be a limit on it.
Well, I know you don't see it as a search, but could the government get a lifetime application under the Stored Communications Act? Would that be adequate? Just renew it indefinitely?
That would depend. In this case, and with Carpenter, that would depend on, like I was saying, about how much the phone company stored. But if the government required that types of information on this very broad and outwardly visible information, that would be allowed.
Okay, proceed.
As shown, the Fourth Amendment ensures one's protections of belongings against the government, but these rights do not apply to broad information such as general location and call records, which are revealed to a third party. Carpenter agreed to the terms and conditions presented by the third party, and the government simply tracked these placements. With taking said information into account, Carpenter was not stripped of his Fourth Amendment rights because the agreement established with the cell phone provider allowed for the locational data to be obtained, making this a fault of Carpenter and not the United States government.
Carpenter, and as we have shown under the third-party doctrine and under Supreme Court precedent, I would like to mention or re-mention the case of Ex parte Jackson, which established outwardly visible information, and that is what this type of information that Carpenter is contesting is. The contents of his communications throughout his investigation were kept private, and the government was able to use this very outwardly, who he was calling, in order to link him to the crimes. This was through the confession.
I'm having a hard time with this part of your argument, though. So in what way is who he's calling an outwardly visible communication? It's not the same thing as a letter where you can look and you see to whom it's addressed, right? When let's say I have my cell phone right here, I pick it up, I take a call, you can see I'm making a call. It might be outwardly visible approximately where I am, but you don't know who I'm calling, right?
Your Honor, I would argue that this type of information is related to the letter. This is an extension of that kind of communication technology, where instead of being outwardly visible to anyone who picks up the letter or the phone, this is similarly visible to the phone companies as it would be to a letter carrier.
Okay. Explain that to me, though. Explain to me how it's outwardly visible in the same way, because you have to go and look for it, right?
Your Honor, this information, as being, you're correct. You have to look for it or request access from it from the phone company. But they are storing this. This is required. This is how their system and network are working and functioning. So they're using this data, and this data is, because they're keeping records of it, it's very similar. Find it very similar to records of letters.
You can continue.
As established, Carpenter holds no reasonable expectation of privacy. The government continuation of gathering the information to link Carpenter to the crime was necessary protocol.
I'd like to further on a point my co-counsel is making, that the government wasn't, as one of your honors, in this case, the government, it wasn't searching him throughout his lifetime, but the government was, through the confession of a robber, was able to use this information to tie them to this crime. The petitioner had said that this information was what relied on Carpenter's conviction. Now, it is what helped tie him to the crime, but it's not what caused him inevitably, in the end, to become convicted. It merely showed to the government that further investigation was necessary.
The act of giving up this information allowed for the government to access it through the Stored Communication Act, which is a justifiable stance for not abiding by the normal warrant process because a warrant was not needed. As aforementioned by my co-counsel, the plaintiff was not searched, rather the government simply collected the information by the third party under the agreement that Carpenter made when he signed his contract through the cell phone provider. Given this supplied information,
Counsel, you have about a minute left, just so you can start wrapping up.
Thank you.
Your Honor, the United States government followed rightful procedure in both obtaining and using information presented during their investigation. With taking said information into account, it is imperative that the Supreme Court rule in favor of the respondent and continue to uphold the standards that guarantee our fellow Americans to be both secure and safe in their persons, papers, effects, and houses. Thank you.
Josh, you are muted still.
Sorry. Thank you very much, Counselor. I'll put you on mute now. And now we have the petitioners. You have 5 minutes of rebuttal time, and you begin whenever you're ready. And please unmute yourselves. Okay, you're still on mute. You are off mute. 5 minutes whenever you're ready.
May it please the court. On rebuttal, I'd like to begin with the opposing counsel's contention that Mr. Carpenter's data under the third-party doctrine bypasses the Fourth Amendment. We addressed the reasonable expectation of privacy portion in our main arguments. However, moving on, the third-party doctrine relies on a separate legal concept for the determination of the reasonable expectation of privacy, that concept being consent. The truth of the matter is that, much like a large percentage of the American population, Mr. Carpenter was unaware that he was being tracked every time that he called someone. Many people are unaware of the fact that the location information that your phone produces as a result of electronic communication is stored, and that the location information will continue to be produced even when your location services are disabled. Mr. Carpenter could not have adequately consented to this record of his location information, as again, he was unaware that that piece of information was being tracked. Further, Mr. Carpenter did not initiate each of the—
interrupt you though, because opposing counsel says it doesn't matter whether or not he did know. He should know because he had to sign the terms and services agreement when he got the phone. How do you respond to that?
Well, Your Honor, further than the fact that we contend that Mr. Carpenter did not know that this was happening, Mr. Carpenter did not initiate each of the instances in which he was being tracked. And the information that was seized in our contention, again, was done so involuntarily. Miller initiated each and every transaction through buying and swiping his credit card and was aware through his credit card records that he was being tracked. However, Mr. Carpenter did not initiate each and every one of the events that caused his location to be tracked. If Mr. Carpenter ever received a text message or a phone call or an email, his phone would be sending his location to the phone company and forcing him to be tracked against his will and consent. Moving on, Your Honor, we would like to mention that in response to one of the opposing counsel's points, the ACLU points out in their amicus brief that the government cannot capitalize on new technology to shrink privacy, and that we would contend that when determining a Fourth Amendment issue, that this court should not just look at who physically holds the documents, as the opposing counsel would contend, but to whose privacy would be violated if those documents were to be given to another party. And in this case, while the phone company might physically hold the records of this instance, it is Mr. Carpenter whose privacy would be violated through giving the documents to another person. And further, Your Honor, the Telecommunications Act of 1996 holds more precedent, as it was created more recently than either the Stored Communications Act, Miller, Jones, Ex parte Jackson. And this states that Mr. Carpenter does have a right to privacy in his cell phone records. No matter what Jones says, no matter what Ex parte Jackson says, or what Miller says. And moving on to, going back to the reasonability point, we contend that reasonability does not just rely on the knowledge of somebody, but it relies on if that person believes that they are protected in this instance. Mr. Carpenter, in our view, did believe that in carrying his phone, he was protected by the Fourth Amendment in any location that might be tracked.
But Counselor, I keep going back to Smith v. Maryland, right? Why is this case not governed by Smith?
Your Honor, Smith versus Maryland only mentioned and dealt with PIN registers.
But it involved pen registers, but the principle can go beyond pen registers, right? Can it go beyond it to sharing information with the public? I mean, you're dialing a phone number, you're turning your cell phone on. Why is it any different?
Your Honor, the difference comes from how sensitive the information is. People, according to Jones, do have a right to privacy even moving through public thoroughfares. And even in Miller, it was decided that the reason that you could not track someone's, the reason that the records, the financial records were so important was because it might reveal a staggering amount of information about the lives of the people you are tracking. Your Honor, the mere thought that a government is watching you chills associational freedoms. It stops you from doing what the amendments and what the founding fathers intended for us to do.
You have 30 seconds left, Counselor. I want to let you wrap up if you can.
Thank you, Your Honor. Again, it is for the reasons stated that I have stated now and the reasons previously stated in our main arguments that we pray this court refuse to allow the government to use the Stored Communications Act to bypass the Fourth Amendment and to rule in favor of Mr. Carpenter, the petitioner in today's case. Thank you for your time, Your Honors.
Thank you very much. I'm going to put you on mute. And we have counselors for respondents. Please unmute yourselves, and you have 5 minutes.
The United States government took necessary protocol under these 3 conditions. 1 being the plaintiff's Fourth Amendment rights were not violated. 2 being there was neither a search or seizure that took place when the government obtained the information under the Stored Communications Act. And 3, the plaintiff had no reasonable expectation of privacy because the information was obtained and was granted by a third party, that being the cell phone provider. As it relates to Carpenter, it is clear there is no expectation of privacy since Carpenter willingly provided information to a third party. He dismisses his entitled Fourth Amendment rights protection. According to the criteria needed to be met by the legal precedent set by Katz v. United States, Carpenter falls short. Carpenter's cell records are not shielded by the Fourth Amendment as he is not given a reasonable expectation of privacy. His rights were signed away when he signed the agreement instituted by his cell phone provider.
There were a reasonable expectation of privacy with the information that Carpenter is contesting does not exist because it was the responsibility of the phone user to understand how this machine, which they have purchased and agreed to use, how it works and how it shares information. It is furthermore that by agreeing to use this, they're agreeing the government does not force the phone on Mr. Carpenter. It did not force him to use or have the phone on in any way. And so this reveals that it was Carpenter's choice to risk the exposure of this information to the government. Furthermore, coming back to the point of outwardly visible information, this type of information that is who is going to is really the same. It may seem it's the same as what was dealt with in Ex parte Jackson. Further replying is that the records being owned specifically by the phone company, and that the petitioner was saying that this older precedent should not apply to this case, which we would respond that the old precedent as well as new is the most important when looking at this case, and that this precedent is an understanding of how the Fourth Amendment works, and that applies to any age, be it in any type of communication, be it with letters or be it with cell phones.
Furthermore, to refute the petitioner's side, they claimed it was necessary procedure. It was instituted by the company, for the company, and not for the individual. The individual, it is for the individual and not merely for the cell phone company. Since Carpenter signed those rights, you have to understand that his locational data could be shared given the fact that we live in a technological world and technology, we're immersed in technology and it surrounds our daily life.
Counsel, let me ask you, if I can ask you a question. Why can't the government just get a warrant here, right? How much more burdensome is it to make an application under the SCA or Communications Act and just seek a warrant? Why don't they just get a warrant here?
The government could have pursued a warrant in this case, but that's not the action that the government decided to take, and it felt that this type of information did not require a warrant.
No, I get that they didn't, right? I get that they didn't, but why couldn't they?
There's nothing preventing, Your Honor, the government from pursuing a warrant in this case, and it is quite possible that a warrant might have even been approved. But like I said, that isn't what happened.
So let me ask a follow-up question from my fellow judge here. Is it really that much more burdensome to get a warrant rather than to use the mechanism set out by the SCA?
The process that the government used here was helpful in the ability to connect Mr. Carpenter to the crime. So I would say that this type of information should be available to the government without a warrant, because it was able to both confirm the confessions of one of the robbers that Mr. Carpenter had been involved and in contact, and it labeled Mr. Carpenter as a person of interest that the government would want to further explore his ties to the case.
But if we say, let's say, you know, we're telling you you're going to be on constitutionally firmer grounds if you just go and get a warrant. You're telling me you actually think you probably could have gotten a warrant in this case. It's not really that burdensome. It doesn't interfere with your, you know, the police's ability to conduct the investigation. Why not just go get a warrant?
And this is going to be the last question. You're almost out of time, but you can finish Justice Silberberg's question.
Thank you, Your Honor. The reason the government, this type of information, of course, it was very, while, as you say, it might not have been burdensome in the case, the government did feel that this was the best way to access information and the quickest. And furthermore, and in conclusion, the respondent has a proposed standard that under the standards instituted by the third-party doctrine, that it should be acceptable for the government to access call records and general location data stored and given up to third-party service providers. Thank you for your consideration.
Thank you.
Thank you very much. Well, this is the final round, the final match. We've had 6 matches, and all of you continue to impress me. You give me hope for the future of a republic, that you have such strong commitments to the rule of law and to the Constitution, and we're all very proud of you. After this round, Justice Silberberg and I will deliberate, and we will announce who are the 2 teams advancing to the final round of arguments, which we held at Georgetown on April 26th. So thank you so much. We were all proud of you. Julie?
I just want to congratulate both teams again. I thought you, both sides did a wonderful job, and you both had clearly staked out positions, and it didn't matter, you know, if we were going to ask you questions to try to persuade you to see things from another side. You held your ground, and you stuck to the arguments that you put forward in your brief, which is, you know, we applaud you for doing that. This was a hot bench today. We asked you a lot of questions. Again, as we had mentioned earlier, that's an indication that you're doing well, that we're really pressing you and trying to get sort of, you know, to the heart of your argument and to press the logic of what you are asserting. So you should be very, very proud of yourselves. Like Josh said, we will be back in touch either later this evening or early tomorrow to let you know who will be advancing to the finals in Washington, D.C.
Thank you very much. With that, court is adjourned.